record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access to our criminal docket, both in the courtroom and also online. We'll start our morning docket with People of the State of Michigan versus Robert Boyd. It's two file numbers, 24-6931FH and 25-77003FH. Counsel, you want to state your appearances beginning with People?
This isn't just another routine court hearing. This is a case where confusion, old records, and high-stakes decisions collide in real time. A defendant walks in expecting one outcome, only for the court to suddenly realize they're looking at the wrong case entirely. But that mistake could have cost her everything: her freedom, her future, and possibly months behind bars. As the judge scrambles to correct the record, the tension rises. Will this error work in her favor or make things even worse? And when the truth finally comes out, the consequences hit hard. Stay with us, because this courtroom moment takes a turn you won't see coming.
County Prosecutor?
Dominic F. Vandrake Jr. Your Honor, on behalf of Mr. Boyd, to my right.
All right, good morning. And looks like we also had a pending contempt tagging along for failing to appear, but with that being resolved by a plea in the absconding case, we'll just dismiss the contempt at this time. It would be redundant. We have in 6931 an R&O habitual third, guidelines 7 to 28, and in 7003 an attempt abscond, guidelines 2 to 17. Have you had a chance to review the report and recommendations with your client?
Yes, Your Honor.
Do you have any additions or corrections to the information in that report?
No additions or corrections, Your Honor.
And do you have any challenges to the scoring?
No challenge to the scoring, Your Honor.
Ms. Goodrich, do the people have any additions, corrections, or scoring challenges?
No, Your Honor. Thank you.
Mr. Andriaki, anything you'd like to say on behalf of your client?
Yes, thank you, Your Honor. Essentially, Your Honor, what we're asking for here is we've reviewed the recommendations. From our perspective, we would request two things. Primarily, first is that when you look at the substance abuse treatment, in the absconding file, Mr. Boyd was at the Harbor Hall. He did leave the Harbor Hall. However, he did turn himself into an inpatient hospital. And upon completion of that program, he went to DOT caring centers, and he brought this morning a certificate of completion where he successfully completed residential treatment at the DOT caring centers. So our first request would be that he would get jail credit for the successful inpatient treatment that he accomplished at the DOT in Saginaw. It's a 30-day program. It's noted on page 16 of the pre-sentence interview report, the CFJ 284. And then the second request from our perspective is Mr. Boyd obviously has a significant criminal history. There's no hiding that, right? However, the vast majority of that is due to alcohol and controlled substance use. Thankfully, through a long and arduous process, Mr. Boyd is taking his substance abuse treatment very seriously. As noted again on that page 16 of the CFJ 284 for substance abuse treatment, essentially all of his treatment comes within, especially the inpatient treatment, within the last about 9 months approximately, from essentially December of 2024 to the present. He is going through AA-NA meetings. And we would request, given that he's staying sober and trying to turn his life around, that the 12 months, be held over his head and be placed on probation for the 1 to possible 2 years, as noted in the report. There are some. It's a little unclear as for the probation officer's recommendations, as the CFJ 145, page 2 to 3 notes that it's for probation of 1 year with credit for the time served of 12 months on the R&O case. But then if you read the...
Yeah, I saw there was a discrepancy in the recommendations between either probation of 1 or 2 years and in the absconding case, whether to place him on probation at all.
Right. Yes. So that's why we would just try to summarize all that up.
Okay.
Thank you, Your Honor.
All right, thank you. Mr. Boyd, it's not required that you would make a statement today, but it is allowed. Is there anything you want to tell me today or no? Go ahead and stand up if you're gonna.
I appreciated that you guys let me go to rehab. I know that I didn't do it right, when I left Arbor Hall, but it saved my life, like seriously. And so I just appreciate that. You've always been fair with me, so I can't go against anything you say, really.
Thank you. All right, thank you, Mr. Boyd. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. We started here on an R&O case where on August 23rd of 2024, the defendant was running into a wooded area. The officer confirmed his outstanding warrant at that time. The defendant was found hiding under an abandoned van. The defendant came out from underneath the van and started running again. The defendant was lying down on the ground trying to hide and was found there, got up, started running away a third time until he was placed into custody. He then was released for rehab and on his own decided to switch rehabilitative facilities and did not return to the jail as court ordered. Mr. Boyd has 7 prior felonies and 21 prior misdemeanors. He is familiar with the court system and the importance of communications with the court. He's 42 years old. He's unemployed with a GED. Due to him successfully completing that second rehab that he chose to do on his own, there was consideration given and a county jail cap was placed on this case. It did not appear to be a prison type case, and also an agreement that the 2 cases would run concurrent. He received the benefit of both of those things. I'm in agreement with the PSI recommendations for 1 year in jail in the R&O with credit for the 207 days already served. I would agree with time served on the absconding. I would suggest the court order the 2 years probation. Even defendant expressed concerns about remaining substance free and had requested the assistance of court supervision to monitor and hold him accountable during the PSI interview. Thank you.
All right, thank you. Well, Mr. Boyd, if you want to stand for the court sentence, please. Mr. Boyd, with the prior record that you have, you've had sort of a lifetime of a series of bad decisions, in and out of jail and prison. And I've in the past, I think I've prosecuted you in the past a long time ago. I've been a judge on your cases. With 7 prior felonies, then of course that means, this is an R&O, and you're looking at guidelines up to 28 months. So it doesn't take much for you to be in prison jeopardy. But that's I think if you reflect on it, that's how it probably ought to be. That people who are first-time offenders ought to get more breaks than people who are 8-time felony offenders. But so you're just in that category, Mr. Boyd. So it's really hard for me to know whether to believe anything that you say about your present intentions. If that's true or not, but you also know it's unlikely that a judge is going to believe those things until you show us. Right? I saw that you did in the PSI say that you wanted, some help on probation to monitor and hold you accountable to remain substance free. You've had some struggles in that area, to be sure. I hope you mean that. I got no way of knowing if you do. I hope you do. I think you seem to have, a fair amount of intelligence where I think you're capable of doing more than what you do. But what you do, Mr. Boyd, the police don't have a really easy job, and you're out there making their life pretty tougher that day. You got a warrant, and they're going out to make a warrant arrest, and you're running and you're hiding under vehicles and you're running from them again. What the heck are you doing? You know how that ends. And even if they don't catch you that day, they're catching you. So I just don't understand the thought process with, that kind of felony record that you're just going to run around from the cops like you're 17 years old in an MIP party. That kid's going to get a ticket. you're going to go to prison. You know, and the prosecutor's right. It's only because, you know, you did complete a rehab that they gave you that sentence agreement. This isn't the kind of case where we look at the behavior and say, gee, we think we want to send Mr. Boyd to prison. But then when we look at his record, it's a little more tempting. So this could have been a case that ended up with you in prison because you're just being a knucklehead instead of just letting them arrest you on the warrant. I don't even know what the warrant was. What was the warrant?
I couldn't tell you.
Yeah.
I don't even know.
I mean, it wasn't a felony or you'd be here on that.
Right.
So you took what was at most a misdemeanor problem, maybe a child support problem. I had no idea, but it wasn't a felony problem. And you turned it into, am I going to prison or not? So I don't know. I don't understand that. In any event, there's a sentence agreement for a county cap and for concurrent sentencing. I'm going to follow that. I think that's fair under the circumstances. It's not my practice to give you jail credit for a time that you were not in the jail. So I'm glad you completed that inpatient, and that's probably why you got the sentence agreement, but I'm not going to give you jail credit against that. So what I'm going to do, taking all those things into account, including the guidelines in file 6931 FH for the charge of resisting, obstructing police habitual second, 3-year maximum, 7 to 28 month guidelines range. I'm going to order that you serve 12 months in the Sheboygan County Jail, give you credit for 207 days previously served, and place you on probation for 24 months, subject to the terms and conditions listed on pages 2 and 3 in the pre-sentence report. Those include a crime victims assessment of 130, court costs of 350, state cost of 68. There's a monthly supervision fee, and you're going to have to complete substance abuse testing and treatment as directed by your supervising agent. I'll indicate on the judgment of sentence that I would approve you for participation in any jail programming, including any CBT classes or trustee status. If the jail determines you eligible, all I'm doing is green lighting it that I have no objection to those things, and you can earn some time off your sentence that way. And that is a sentence within the advisory guidelines range. I think it is proportionate to the circumstances of the offense and the offender, taking into account his extensive prior felony record. In file 7003 FH, I'm also going to place defendant on probation for 24 months, subject to the same terms and conditions. And order that you serve 12 months in the Sheboygan County Jail for that as well. And on that one, you have credit for 140 days. And there'll be a crime victims assessment of $130, state cost of 68. I'm not going to assess court costs in that file. And in that file as well, I'll order that you can participate if the jail determines you eligible in any programming, including CBT or trustee program. That again is a sentence within the advisory guidelines, and I think that it's proportionate to the circumstances of the offense defender. Mr. Boyd, if you wanted to file an application for leave to appeal, you could. If you wanted me to give you a lawyer, I would. You'd have to ask me within 6 months. So we're going to hand you a piece of paper explaining that appeal process, ask you to initial one copy for us, and the other one's for you to fill out if you want to take an appeal. Good luck to you, Mr. Boyd. Within 24 hours of release, you have to contact your supervisor.
Exactly.
But on page 2 of the CFJ 284, it recommends 12 months incarceration.
Those are the two issues.
All right, so Agent Fagan, which one of those is your recommendation, and can you change them both to be the same?
The 6 months, Judge.
Okay, all right, so we'll just change that 12 to 6.
Thank you very much.
All right, any other additions, corrections?
There are none. Thank you.
Okay, in the advisory guidelines in the new file, the home evasion file is 0 to 17 months. In the probation files, the only one that really matters is 6891 is 51 to 170 months. Any scoring challenges?
I do not find any challenges to the scoring.
Any additions, corrections, or scoring challenges from the people?
Your Honor, part of the plea agreement was restitution in the amount of $300, and that was not carried over to page 3 with the recommendations. So I just asked that be carried over.
Oh, okay. All All right, anything you want to say on behalf of your client?
Your Honor, even when I read through the PSA, there was one thing that it stood out to me that said, she blamed others for what has happened to her. And at least with my conversations, and granted, my situation with my client's different than most other people, but she has always, in all these files, I've been the attorney with her, has always said that she was at fault, and that she's always had a culpability when I've had conversations with her. So when I read that, I was a little perplexed by that, but that's how she came through in the interview. However, I had not seen that. And I think that was something I need to point out to the court, that even with this last issue, when she knew with the home invasion that was going to terminate her from the recovery court, and I think she was making progress in the recovery court, at least gaining some tools. However, implementing those tools when you're not in a structured environment is a lot different. And obviously, she did not do what was quite right that night with this home invasion, which put the recovery court into a situation where they couldn't have her any longer because of that type of activity. And right from the initial meeting with her, she understood that. And again, like I said, I haven't seen where she blames others or did not accept the responsibility. And I would ask the court to possibly depart down in this case from what's the guidelines say. She understands she's going to do a prison term, and we know that's coming. However, I would ask that the court consider the minimal amount that the court deems fair. Thank you.
Okay, thank you, Mr. Gilbert. Ms. Armbrewster, is there anything you want to tell me today?
Yes, Your Honor. I want to say thank you to you and the rest of the recovery court team for another opportunity to better my life and make an honest effort at working on my recovery. I did complete an extensive rehab program through Harbor Hall, and I have been clean off meth for 8 months. My family and friends did notice big changes in me, and for that I am so grateful. After leaving treatment, however, I did realize I don't just have a drug problem, I have a trauma problem. Until I can heal my past traumas, I won't be able to adapt to the honest recovery program I want for myself. I want to also apologize for the negative effect my addiction has had on the community. In my addiction, I not only hurt myself, but I let down and hurt the people who care for me and love me the most. And some are forced to make hard decisions and set some serious boundaries with me. It's unfortunate that this day has come, but I know God has a bigger plan for me. I have a good mindset, and I'm looking at it as an honest opportunity to focus on myself and make positive changes towards the life I want, so I can come out being a sober, productive member of society again. Thank you.
All right, thank you. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. The defendant has 7 felonies at 31 years old, and looking at the timeline, she committed her first felony only 5 years ago and 6 more after that, which is a short time frame. She's committed this additional crime while on probation for others, as well as the violations that she had in a short amount of time that she was in recovery court. She previously has served 2 jail sentences, 4 terms of probation, so services have previously been offered, as well as the current attempts for recovery court and the prior attempt for recovery court. Given those circumstances, I don't believe the low end of the guidelines are appropriate. However, it would be her first prison sentence, so I don't think high end of the guidelines either are appropriate. I request the court to order somewhere in the mid-guideline range. Thank you.
Thank you. Well, Ms. Armbrewster will handle the new file first, 25-6984. You're here for sentencing on an attempt home invasion third. Oh, Agent Fagan, I did have one change in that report. The statutory maximum for the attempt remains 5 years. It changes the grid, but the statutory maximum remains the same at 5 years. If you could make that change. Anything to be heard from the defense on that question?
No, I would agree.
From the people?
I would also agree.
All right. The advisory guidelines are 0 to 17 months. Those would typically call for an intermediate sanction without incarceration unless there's reasonable grounds to do so. Here, there is reasonable grounds for incarceration in that you committed the offense while you're on probation, and not just a probation, but in the recovery court program. And this was the second time that we let you into that program, and the second time that you've not successfully completed it. And that was, I'm sure, a disappointment to you. It's a disappointment for us as well. When we decided to take you back into the program, it's because we wanted you to succeed. We don't have anybody come in wanting them to not succeed at it. What's troubling here is that while you're in intense supervision, you're still engaged in felony conduct. And even when that was initially charged, the original charge is for home invasion third degree. The way the home invasion statutes are written, those facts would have also supported a first degree, which is a 20-year Class B felony. And you could have been looking at a lot more time as well. So I think, through the charging decisions and through the plea bargaining process, you've certainly been treated very fairly about the situation. I do think that that given that you committed that while on an intensive probation, that I am not going to follow that recommendation. This obviously won't be the case that drives the bus. We'll get that in a second. But on this case, the 6984, I'm going to order that you pay a state cost of $68, crime victims assessment of $130, and $300 in restitution. And I'm going to commit you to the Michigan Department of Corrections for a term of not less than 13 months, nor more than 5 years, with credit for 121 days previously served. And that is a sentence within the advisory guidelines with the reasonable grounds for incarceration being placed on the record. We'll do the appeal right to the end on all. All right, and in the probation matters, first in file 24-6814. That's you're on probation for possession of methamphetamine with the drug double. Advisory guidelines at 0 to 17 months. In that file, I'm going to follow the recommendation and revoke your probation and order that you serve 140 days in jail with credit for 140 days previously served. Any fines and costs that were assessed remain due and owing in the amount of any unpaid balance. So in that probation, it's revoke, discharge unsuccessful, and time served. In file 6862, that's possession methamphetamine drug double and a use of methamphetamine drug double, the advisory guidelines of 10 to 23 months. I'm gonna follow the recommendations in that file and revoke your probation, discharge you as unsuccessful, and order that you serve 205 days jail with credit for 205 days previously served. Because it's a straddle cell, the court can impose an intermediate sanction with incarceration. So that's not actually a downward departure. Any fines and costs assessed in that file will remain due and owing in the amount of any unpaid balance. So again, Ms. Armbrewster, that file will be revoked, discharged, and time served. And then that brings us to file 24-6891FH. That's a charge for delivery of methamphetamine habitual forward. And the advisory guidelines are 51 to 170 months. That was your second time into a drug treatment court program, a problem-solving court, trying our very best to avoid sending you to prison. And then while you were in that program, you engaged in new felony conduct that was a crime against a person. So it's appropriate to revoke your probation and discharge you as unsuccessful in that matter. Any fines and costs that were assessed remain due and owing in the amount of any unpaid balance. And so we have to decide, you're obviously, as you know, going to going to go to prison today, and the question is for how long, then the advisory guidelines are 51 to 170 months. This is your first prison commitment, so I don't think that an upper end is recommended. But here I have to take into account, even though I've given time served on the other files, there were a number of different felony cases going on. And then while I've got you on probation for a treatment court, you're engaging in more felony conduct despite the real close supervision. And we were really engaged with you. I thought we saw, the first time you came through, you had kind of a really rough edge to the attitude. And the second time, I thought we saw some chinks in that armor and some sincere willingness to engage in the services. But you weren't able to control your conduct when you had a disagreement with the victim in this case. And so I think all those things into account, a sentence on the lower end is appropriate. The recommendation from the Department of Corrections fits the bill. It is measured and proportionate. So I'll commit you to the Michigan Department of Corrections for not less than 60 months, nor more than I'm going to exercise my discretion. There is a habitual hold to increase the statutory maximum to 30. So it's a 5 to 30 year commitment. You're entitled to credit for that one has 122 days credit. Right, and that is a sentence within the advisory guidelines. I do think it's proportionate to the seriousness of the circumstances of both the offense and the offender. All those sentences will run concurrent with each other. All right, so Ms. Armbrewster, you can file an application to appeal if you want in any of those 4 files. If you wanted a lawyer, I would certainly give you one. You'd have to make that request within 6 months. So we're going to hand you 4 sets of these appeal paperwork. So there's 2 copies in each one. We're going to ask you to initial 1 copy in each one, so we have a record that we gave it to you. And the other one is for you to fill out if you do want to take an appeal. Do you have any questions for me about any of that?
No.
All right, Ms. Armbrewster, I know this seems like a very long tunnel, but this, I assure you, is going to go, it might not go that fast, but it will go. And so you'll be back in our community at still a very young age and still have many choices to make, both when you're inside and when you're back. So I hope when you're back, you stay on a better track, because now with this record, if you have more felony conducts, we can't go low end of the guidelines anymore. And you see from these guidelines, if you on parole engage in more felony conduct, it's going to have to be a really long sentence. And I certainly hope that day doesn't happen, Alyssa. Good luck to you.
And just like that, the final decision is handed down. And it's a tough one. Probation revoked, a financial penalty of over $1,000, and a 93-day jail sentence, though partially reduced if payment is made. The judge did acknowledge that she stayed out of trouble for years, but ultimately the repeated failures to comply with court-ordered programs carried more weight. This case is a powerful reminder of how quickly things can escalate when obligations are ignored, even years later. It also shows how critical it is to stay engaged with the legal process, no matter how difficult life gets. Now, I want to hear from you. Do you think the judge made the right call here? Or should more leniency have been given considering her circumstances? If you found this case as intense and eye-opening as we did, make sure to hit that like button. Plus, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.